Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair.
Another threat. Wow.
You're probably going to hear more than one. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn and I'll continue to up the ante. I don't give a shit if you object. Is it clear what I said? I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two
Have you ever had a grilled cheese?
Other issues as well.
You're in contempt of court. Put him in jail.
Ego parade begins ****. The hearing kicks off with chaos as our self-declared sovereign citizen refuses to even sit in the defendant's chair. Judge Oakley, calm but firm, orders him multiple times to sit down or face a bench warrant. The defendant dodges basic questions with cryptic legal jargon and tries to play courtroom philosopher. But Judge Oakley isn't having it. He lays it out clearly. This is *** courtroom, and the law isn't up for debate. When asked whether he is representing himself, the defendant dances around the question, spouting nonsense about not having a lawyer.
You're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry, officer.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen. And
no, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has...
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on a record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution?
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding your oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have...
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May I?
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today.
You have a jurisdictional argument you want to make?
Well, I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or
multiple
no?
Himself. It's classic sovereign citizen behavior, twisting words and stalling proceedings under the illusion of legal knowledge. Oakley patiently unpacks his answers, staying cool while slowly boxing him in. #*** clip 3. The injured party circus ***. Next, this guy unveils a fan-favorite sovereign citizen myth. There has to be an injured party. Apparently, unless someone hobbles into court with a bruise, this man thinks laws don't apply. But Judge Oakley shuts that fantasy down, explaining that the state itself is the injured party in criminal cases. Things escalate when the defendant won't stop interrupting. Oakley gives a clear warning. Speak out of turn again, and you'll be fined. Of course, the guy doesn't listen. He blurts out an objection, gets slapped with a $100 contempt fine.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record. Is it?
My jurisdiction.
It's only two.
Sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
this? Is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right, where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so.
You said you wanted a sworn complaint.
From an injured party.
When asked to give his name for the record, he refuses, earning another warning and more side-eye from a bench. At this point, it's a masterclass in courtroom patience from Judge Oakley. The judge holds a line ****. An asterisk this asterisk is why people love Judge Oakley. While some critics say it's too aggressive, most of us understand. Dealing with sovereign citizens requires steel nerves and no tolerance for games. His mix of firm discipline and clear logic is exactly what's needed. These courtroom disruptors waste time, dodge responsibility, and cost taxpayers money, and Oakley doesn't let that slide. He keeps control, enforces courtroom rules, and delivers just enough sarcasm to remind everyone who's actually running the show. If anything, his reactions are measured, considering how far off the rail.
Who have I injured for the record?
The state of Michigan
How can I
are bringing the charges.
How can I injure the
state?
Sir,
sit down. Sit down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge. The people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration, with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name?
No, you still will.
That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference, and I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Defendants often go. Judge Oakley isn't too harsh. He's exactly the kind of no-nonsense presence we need in today's legal system. Sovereign citizens count on chaos, but he brings order. Let me know what you think. Was Judge Oakley's handling perfect, or could he have gone even harder? Rate his performance 1 to 10 in the comments. Let's hear it. The judge holds the line asterisk. And this asterisk is why people love Judge Oakley. While some critics say it's too aggressive, most of us understand. Dealing with sovereign citizens requires steel nerves and no tolerance for games. His mix of firm discipline and clear logic is exactly what's needed. These courtroom disruptors waste time, dodge responsibility, and cost taxpayers money, and Oakley doesn't let that slide. He keeps control, enforces courtroom rules, and delivers just enough sarcasm to remind everyone who's actually running the show. If anything, his reactions are measured, considering how far